Yes, please first unmute. Yeah, thank you. And even Mercy, I've sent you a request to join us as a speaker. Yeah, yes, unmuted. Yeah, thank you for who have joined us. We shall be beginning the next 2 minutes. You could just use these 2 minutes to share the link with your colleagues, to also just use these 2 minutes to share the link with your colleagues, to also settle in, to listen to unit. Good morning, good afternoon from wherever you have joined us today. For those who have joined us on NextPay, thank you for us. She's a formidable legal mind. Most of you may have come across us. She's a formidable legal mind. Most of you may have come across her in the court corridors trying to ensure access to justice. She has also served ULS in different capacities. Still joining us today is Mr. Aaron Besije. Mr. Aaron is the National Coordinator for Justice Centers Uganda. He's a very passionate advocate ensuring that justice reaches those who really need it, the poor ones, the vulnerable ones, and those at the grassroots. So from the courtroom corridors to the front line of legal aid, we have two passionate advocates who are here to share their powerful stories, to share bold insights and immediate reforms needed for our justice system. You're most welcome. Mr. Wilson, it's your turn to say hi to us, introduce our guests, today's guests, and we dig deep into the conversation.
It's a great honor to be here. Thank you, Raymond. Thank you, Mercy. Thank you, Alfred. And thank you, everybody who has joined us on our reggae conversations. As you all know, nobody can stop reggae. And we are extremely honored to have Mr. Aaron Besije and Ms. Anne Karunji. These are two well-known names within legal circles in the practice of law. They have offered themselves for service. At one time, I think Aaron was our CEO at the Uganda Law Society. I know Anne has served on the ULS Council. They are also formidable legal practitioners in their own right, in private commercial practice, Anne Karunji, and in as the coordinator of Justice Centers, Aaron Besije. And I think these sort of conversations bring a fantastic perspective to access to justice, to the corridors of justice, and to how we can make justice just, because justice at its core must be just. And because lawyers are the firebrand of society, it is my honor and privilege to have these fantastic, able lawyers, well known in legal circles, people who have something incredible to contribute. And of course, welcoming everybody who has joined us and saying good morning, good afternoon, and good evening to you from wherever you're joining us from. And I want to start with you, and how are you?
Good evening, Harrison. And am I clear? Am I loud and clear?
Very loud, very clear.
Amazing. So once again, I thank you, Ellison, for inviting me to such an have such a a timely conversation in such a space. Yeah, I'm glad to be here.
It's our honor to have you. Aaron, over to you. How are you this evening?
Yes, good evening, Edison and the listeners. Yeah, it's been a very great opportunity for me to participate as a speaker. I've keenly followed this conversation as a listener in the various series, and when with this group of our clients, especially the clients that I represent, be on the topic. And I'm glad of that category of people who form the majority of the Ugandans, whom we all, in one way or the other, whom we have offered help. So it is an honor for me, and I hope that we will have a very beautiful discussion. Thank you for the invite once again.
Thank you so much, Aaron, for that fantastic introduction. And maybe we'll start with you. We usually begin with this question to both panelists, and we'll start with you, Aaron. Just if you could briefly tell the listeners about yourself, very briefly about yourself, about what makes you tick, what makes your blood boil, what makes your heart beat faster. Just tell us something about Mr. Aaron Besige.
Thank you very much. My name is again Besige Aaron. I'm currently the National Coordinator of Justice Centers Uganda. Justice Centers Uganda is a government of Uganda project established within the judiciary by the Previously, I also worked with Uganda Law Society as again head of the Legal Aid Project, and I think many of you knew me from that angle. We made the expansion of the Legal Aid Project 22 clinics before I crossed and served as the treasurer of the Uganda Law Society. I think we are the pioneers even among the group that the current one. And that's briefly actually about me. What boils me for the rest of my life, right away from the law school, I've served that community of the vulnerable, and I think it is my niche, but also it is my passion really to say that justice is also served to those vulnerable communities whom we actually, in most cases, disregard.
Thank you. Thank you, Aaron, and thank you for being moved by the plight. There's somewhere where it's written that whoever cares for these, the least of my brothers. I don't know if it's a song. I think it's a verse. Raymond is telling me it's a verse. You know, Raymond is scripturally perpendicular. He says it's a verse. Whoever cares for these, the least of my brothers, they care for me. What about you, Anne? Tell us about yourself. Anne Karunji. What makes you tick? What makes you boil? What makes your heart beat faster?
Thank you, Ellison. Yes, once again, my name is Anne Karunji. I'm an advocate of the courts of judicature in this country, and the owner of the law firm known as Karunji and Partners, Advocates and Solicitors. Like Ellison earlier mentioned, I have served on the Executive Council of the Uganda Law Society and also unsuccessfully ran for president. I was sent to Taiwan, but that's okay. I will try another time. My area, I'm passionate about the rule of law. Whenever called on any forum to discuss matters to do with the rule of law, I I will jump onto the topic and I will ably present myself. I am passionate about the rule of law and the upholding and respect for fundamental human rights. Because everything that we do, our profession, the delivery of services in this country is hinged on the respect for fundamental human rights and the rule of law. Because if the law is not allowed to rule, then we will find ourselves in a state of anarchy. So that is why we cannot shy away on issues to do with the rule of law and the respect and upholding of fundamental human rights. In as much as I'm a very good litigation lawyer, anytime you have a case and you need someone who will, run to, I'm available. Thank you.
I agree with that last bit. We know the fire in the belly that comes to the practice of the law.
I'd like to start here. We've been prosecuting a case on this basis for over, I think, 3 months now. The quality, consistency, and nature of decisions that come out of court, but more particularly the backlog that arises from court matters.
Maybe he's on now again. Let's see if you can hear.
I've been relegated to using another phone now. My question is that important. I have to ask it through as many forums as possible. But Anne, we just wanted your initial thoughts on case backlog in the courts of Uganda. What are your initial thoughts about it? How do you think that we should solve it? Do you think it's a problem to start with?
Thank you very much. Of course, case backlog is a big problem in this country. Case backlog is one of the pressing issues that we are facing as a nation. For example, if you look at a case in point, the commercial court, there is a time, I think that was sometime last year, when I had a conversation with an officer from the Uganda, and he was telling me, Anne, there are trillions of shillings or billions of shillings that are tied up in the commercial court. And he said that the World Bank is willing to facilitate anyone who will provide a solution on how to unlock the that is held up in court cases in the commercial court, because it holds the economic development or the economic progress of a nation. Investors who come into the country find themselves, tied up, or their investments tied up in court matters. That cannot move. So you find that there is a glaring and big issue that if it is not addressed, if solutions are not found, then we are bound to lose out as a country. And that is why spaces like this and conversations like this are pertinent and timely. Yes.
Can you also tell us a bit about the non-commercial cases, the case backlog that's stuck in the non-commercial? And I mean, you did mention that you love human rights, the rule of law, and some of the cases that are, for example, at the High Court. What do you have to say about the backlog in the courts there?
I gave the commercial like an example, but backlog is everywhere. In land matters, there's a time I handled a land matter in the Court of Appeal, which started, I think, I wasn't born. In 1960 something, then the children, the people who had filed that suit, it was a landmarker, died. Their children took over the case. I was handling it, I think, with Edgar Cavaro. The children took over the case. The children died. The grandchildren took over the case. So by the time, by the time the matter was, the judgment of the Court of Appeal was delivered, it was read. In 2015 or something, just imagine how the status quo had changed. Families who are waiting for the fruits of justice had passed on. Now, if there wasn't anyone to inherit the case, that means that it would be absurd for such a family. So now those are the issues that are facing us as a nation. You find that by the time someone realizes their fruits of justice, either the parties have met over work in their villages and settled the matters, or they are no longer interested or the land has changed hands, or some crook has dragged his way and taken it. So backlog is critical and serious, and it affects all courts. It affects in the Court of Appeal. They told us that it will take how many years to reduce the backlog by half? I've forgotten the statistics. But you find that right now they might be even hearing cases of 2015, 2014, 21. So it's a glaring problem.
Yes, I think there are more than 12,000 appeals currently pending in the Court of Appeal and counting.
Yes, thank you, Madam Anne. You have painted really a fair picture of case backlog in commercial courts and how it's affecting the commercial interests of the country. But just taking the conversation to the vulnerable ones, I will go to Mr. Aaron. Mr. Aaron, as the coordinator of Justice as Uganda, you understand you are the front line of access to justice by the vulnerable. So, because you seem to serve the country's most vulnerable litigants. Now, based on your frontline experience, do you believe Ugandan courts are accessible to the ordinary citizens, the vulnerable ones, in terms of cost, physical distance, fairness, transparency, and even, do they even know what happens in court? Because you deal with the poor ones, the literate ones. How accessible are the courts to the people you serve? Thank you.
Thank you very much. But briefly, I just wanted to add some things more on what my colleague Anne had said on the impact of the case backlog, and basically on human rights. Yeah, as someone who has been really in the trenches, especially protecting the rights of the vulnerable, I want you to paint a picture. Matters. Because of case backlog, we are having people who have been kept on remand for years. Just the last week, we have someone who came to our office seeking for legal representation. And the suspect has been on remand for 8 full years. Mind you, this is a suspect. The presumption of innocence is a non-derogable right. But someone has been on remand and his case has never been heard. Just imagine, I'm sure, thank God that many of us listening here have never been to prison, at least as prisoners. I know we have been to prison to get instructions or maybe to acquire information from our clients for defense purposes. But even a single day in prison is enough to change the entire life of an individual in a negative way. So we are having so many people languishing in prison innocently because of this case backlog. Their rights have been shattered. Their families have been shattered. Some of them are coming back when their wives have been taken, when their husbands have been taken away, their properties have been taken away. And for me, as someone who has been defending the vulnerable, we find exactly that the rich have used and taken advantage of the case backlog situation to fight civil matters criminally. If I have land and we are fighting with somebody, somebody who might know that he cannot afford to have their way through the system, then I frame a criminal case against the person. And most cases now, the cases they have been framing people is defilement. So that they slap on you a charge of defilement, and by the time you clear yourself and coming back, to accept to plead guilty on cases they never even committed. So we are finding so many innocent people just running around now with a plea of conviction on their own, but because of the circumstances and having their cases, because their cases could not be heard within the stipulated time. So we can go on and on and on and speak about the effect of case backlog within our system, and it is very 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 sad that, especially when it comes to human rights, that people are being violently abused by the system that is actually meant to protect them. Now, in terms of accessibility of our vulnerable communities, it is a tall order. It's a tall order because we all know that the majority of people whom we represent cannot even afford transport to come to court. I can assure you that we have a special fund for that we give to some of our clients who cannot afford even on a scheduled date. These are the type of grants that exactly that, especially the rich that are taking advantage of. They know that you cannot navigate yourself through this complicated legal system, because we know that look for example at get the system at high court level, and most of the cases now that where especially land grabbers using that as a means to deprive these people. So what happens, for example, a poor person can never present themselves at the court. No, at the high court level. You even don't know how to draft the document. Even the judges actually don't even to listen to you.
Yeah, it's breaking. You tell me.
Aaron, I think you're breaking and you're making a powerful point. I think I was waiting for Aaron to come back. He's basically saying that backlog and delay have become the refuge of the scoundrel, the land grabber, and the thug. And that poor people have no access to justice, that they cannot navigate the system at the High Court. They cannot navigate the system. They cannot prepare the pleadings that are necessary for themselves, and they can't even get audience or a hearing before their lordships. I think, Aaron, you're back?
Yes, I'm back. Sorry, I think the network had somehow interrupted.
We can hear you now loud and clear.
Just the cost itself. The cost of representation is very, very expensive. I can assure you, let me tell you, it's not actually not the ordinary people that we represent. Even amongst the lawyers, majority of all lawyers can never even. Situation where we actually had even to contribute money for our colleagues who are having difficulties, especially to maintain themselves. So we having even those lawyers. So if I'm not talking about these vulnerable communities within our communities, how even ourselves, the lawyers, as vulnerable. So, in terms of geographical coverage again, we find that we're having a barrier, for example, for on accessibility. These local people, first of all, they don't even have transport. the distance from where they are to courts and to other justice institutions are very, very far. And you need to give real credit where it is due, to thank the judiciary that has tried so much to decentralize, especially at the magistrate level, where they have really, really gone now. We are almost having every prosecutor having at least a grade one magistrate. That's a big plus. That's a big plus, and that should have done maybe 10, 20 years ago. But that still remains itself a big challenge. Yes, we are having, for example, the court there, but we are having another arm of government that is not as facilitated as the courts. For example, when you look at the DPP, these are the challenges that we keep facing. You reach in the court, there is a magistrate, but there's no set up to prosecute the matter. So you find a redundant grade one magistrate seated, but having no cases to hear, because we can never have. So if we are going to talk and it will come maybe later areas of discussion, we need to have reforms that are cut across justice institution and not having just one institution shining and leaving others behind. Yes, so that's what we really say in terms of that, and we find that even in terms of fairness, our communities and here we have both perception and real corruption within the court system, and that one further complicates the type of clients that we present. They don't have money. They cannot bribe their way within the system, even when you know that bribery is really unprofessional. But we all know we live in Uganda. How it is. Even just having your cases heard. If your file by luck gets misplaced, even to find it itself, you must pay the court clerk. And we all know this. Many of us on this forum, we have done that. We have facilitated the so-called facilitation to the law clerks to have our way within the system. So that's but now that's what I can restate. I know we can spend the entire night discussing about these challenges.
Thank you so much, Mr. Aaron. I know Mr. Aaron and Madam Anna have painted a picture of the impact of case backlog on access to justice with 8 years on remand. We have also painted a real picture of how the legal system is complicated for vulnerable to access justice, and how now courts are being used by land grabbers to grab land instead of maybe others getting access to justice or to have their land recovered. At this point, I understand Marcy must be having a burning question to ask either of you. So Marcy, you could first unmute and ask your question. Thank you. First increase.
I'm not sure that we can hear you, Mercy.
Yes, you can.
Okay, thank you. Thank you very much, Aaron, for your feedback. My question is to Anne. Anne, looking at your position as a managing partner at the farm, with different courts and business, being able to get different judgments at different maybe divisions and commercial, civil, land. My question is judgments you're getting and the quality of your experience in dealing with the different courtrooms, because obviously as a lawyer your bread is buttered in these different courtrooms, in your ability to get quality judgments for your clients and judgments that come at the right time as well. So I'd like to understand what your experience is and whether you appreciate that that's happening in the different courts at this particular time. Thank you.
Thank you very much for that question. From my years of experience, in terms of quality of judgments, if you look at the judgments from the courts of record, that is the High Court, Court of Appeal, and the Supreme Court, they are not as bad They are not as bad. But when you look at judgments from the lower courts, like the magistrate courts, as in them are oblivious of the law or the position of the law as it stands. There are few, of course, eyebrow-raising judgments from, let's say, the High Court, whereby you get a judgment and you know that either, with all due respect to our judicial officers, that either a judicial officer has either been compromised, is a gambano to another person who is a party to the case. Maybe there are other powers that have influenced the outcome of the decision. Because if you look at our judges in the Court of Appeal, the High Court, and these are, good caliber judges. At least they have a good appreciation of the law. So when they choose to close, they call it close your eye. They go blind your eye or close one eye. When they choose to close one eye in writing a decision, either they have done that knowingly and are pretending to be oblivious. So you receive a judgment and you're in total shock. And you're wondering, my God, did this judge and maybe it can also be maybe a lazy judge can just tell the legal assistant, do the research, write a decision, type it. But those are pockets. What in the courts of record, I would say those are pockets of judgments that we receive here and there. That we know the reasons, even we the lawyers know why it has turned out. We are in shock, but we know why it has turned out the way it is. Yeah. But if it comes to these other lower courts, there is need for ample training. There's a matter that I was handling in one of the magistrate courts in Kampala. And there was a mother who was being denied joint custody of together with have joint custody with the father of her child. And when I read the judgment, because I had been called in and the file had been brought to me for purposes of filing an appeal. So when I read the judgment of this magistrate, she said the mother was acting funny. I will not award custody to the mother because she was acting funny. She went to the boys' school and she was acting funny. In total disbelief, I had to go and face the magistrate to ask her, Your Worship, please explain to me what did you mean in your decision by saying the mother was acting. You deny a mother the right to have custody of her child, you must have sound legal reasoning. Either she's of unsound mind, either she's violent and harsh towards her child, either she has not been in the life of the child since inception. So by the time you give legal reasoning, a judgment, you must have a sound judgment that has legal reasons why you're denying a parent access to their child. But in the lower benches, there is need for ample training of magistrates. You find that innocent parties suffer the consequences. If you have a lawyer who is also well, in it for the money, maybe not to see that justice is done, he might not proceed to appeal the matter. So you find that the party, suffers or is denied justice because of failure by these magistrates to appreciate the law. So you find that in the courts, in the superior courts, we have eyebrow-raising decisions where we are reading and there is no reasoning. There are some decisions you receive from the courts of record, but those, like I said, a few whereby there is no legal reasoning also. The man just comes and, throws the paper there. If you want to appeal, appeal. Yeah. And in terms of timeliness, of course, I will say there is no timeliness of decision making, of output of judgments. You find that you file a case in, let's say, 2022, and it's a commercial decision, and to date, you have not received a decision. It's a commercial, claim involving a lot of money, and to date, you have not received a decision. So you find that there are many land matters, like I said earlier, you find that parties die, land changes hands, because there is no timely delivery of judgments. Then also, I think basically that is it. We have a problem. Either the judges, you find that some judges are lazy, and they keep wondering if you know that you're lazy naturally, because if you know you're lazy naturally, why do you apply to be a judge? If you know that you want to chase so many things out there, why do you apply? Because remember that the people are looking to you for access to justice. People are looking to you for justice. You go to court, the judge is on leave. There's a case I'm handling in Ginger. The first time I went there, the judge was on transfer. Another time I went there was a new judge who had assumed office and gone on leave. You people, I have a client who is in Canada. Now, this matter has taken now almost 2 years without a hearing. Either the judge is on transfer, the judge is on leave, the judge is handling a criminal session somewhere. So you find that it paints, first of all, a bad picture to us lawyers who have already been paid legal fees. We are facilitated to handle these cases. But it also paints a bad picture to the judiciary of Uganda. Because these guys in developed economies, that's not how they work. There's a time I told him, you know what, you have to wake up because of the time zones. You have to wake up early. I'm going to tell court to create a Zoom meeting for you. The man woke up, is it at 3 Canadian time or something? I don't know. He sat in and he said, Anna, I'm alone here. Where are the people? I told him, unfortunately, the judge is not in office. So it is really, there is no timely, like you asked, there is no timely delivery of judgments. The judiciary needs to wake up from their sleep. And also quality of decisions at the lower bench is very wanting. There is need for adequate training of those magistrates, yes.
Yeah, thank you. Sorry. I remembered why when Mr. Aaron was submitting, he almost even started giving reforms which needs to be done urgently. And I think I've been a victim of not even on the judicial officers not being present at court, but when Mr. Aaron was mentioning of state attorneys not being enough to also serve justice, it's a matter where I'm on watch brief and I've appeared with my witnesses for like few occasions, and every time state is not around, and then we have to get another state to adjourn these matters. At one point, I almost felt like why we do private prosecution and I lead my witnesses and I go away. So it painted a picture that maybe the whole justice sector needs reforms, not only maybe judiciary, not only the state attorneys, also the DPP, like everyone in the justice sector needs some reforms. So from that point, my question to Mr. Aaron is, from your experience, you have worked with ULS, now with justice centers, what immediate reforms are needed to enable access to justice, like both in the whole justice sector, because it involves judiciary, also the DPP, even private practice. So what immediate reforms can we employ to have enable access to justice to everyone, either the vulnerable people, even these ones who are maybe commercially aware of how they can access justice? Thank you.
And the listeners, once again, first of all, we need to note that we need comprehensive reforms of the justice institutions. And we will have no solution or one formula that fits all, because all these justice institutions are unique in nature. For example, look at the judiciary. We've been talking about the case backlog. What do we need to reduce the case backlog? And for me, there's no shortcut. It clear the existing cases and stop and find a mechanism of actually stopping new cases being filed within the judicial system. But I have like 3 solutions. One, we all know that under Article 142 of the Constitution, it empowers actually the judiciary and the government to have a mechanism where we can actually employ people, fit people who can act as temporary judges. And we all know that if we don't do that, the problem of case backlog is not going to end now or even the next 20 years. But if we employed temporary judges, we would actually clear these backlogs within the next 3 years. And then we start on a clean slate. Because we all know that these temporary judges, first of all, it is a cost effective. Employing one judge alone, for example. You know, a new judge now comes with a brand new car, which will not cost less than almost 500 million. A driver, bodyguards, what? All those costs are, and we would actually do away with such a cost. So it would be cost effective for us to have temporary judges to be deployed and clear of these cases within the system. Being fired. There are certain come into the system that should not be within the system, that just clog the system for nothing. And that's, I give you an example, for example, that the cases we handle at justice centers. By the way, 80% of the cases we resolve at justice centers, we resolve them in our offices. Court system. Because actually, we found that actually that some of these cases don't need to enter court system them through alternative dispute resolution. So why we actually not encourage and have more centers that actually would actually help in mediation, would actually help to mitigate some of these cases coming into the mainstream system. So that would actually, one of the things is that the state should actually take its full responsibility and establish a state legal aid scheme that is going to help the poor, the vulnerable, and also increase on the number of cases that are actually resolved within a given year. And this is the argument we have been making to the state. The cost benefit analysis of providing state legal aid scheme to the nation. And it has actually shown that it would be very cost effective if the government that would actually help in addressing some of those barriers of access to justice. The third would be us coming back into our informal system. The research has been shown that majority of the people, actually 80% of the people, of our clients that we serve, believe in the local council court system, in the traditional system, in the religious system. And these are doing a very great role in enabling some of these cases actually not reaching the system. And for me, my role is, my suggestion would be that we need to strengthen even those institutions. We need to strengthen the cultural institution. We need to strengthen the religious mechanism in conflict resolution, and also we need to strengthen the local council court system, because some of those cases that actually are coming into the system now should be resolved at the local council level. We should not allow them to come up to the court system, and we only reserve the worthy, really complicated cases that could be filed within the system, and not allow every case to just to pass through into the administration of justice mechanism. That's really my thought with regard to the possible reforms that we can have.
And I want to talk about the first point that Aaron has spoken about, the appointment of temporary judges. And you've just given us an example of the ability to have a court hearing by Zoom where only the litigant is present, having woken up at 3 a.m. in Canada. Would you agree with me? Because we've been making this argument here, and actually I don't know your position on it. We've been making the argument that where the state of the business of the court so requires, and it is my contention that if an advocate of the seniority and caliber of Anne is driving to Jinja for 2 years, looking for 1 day to be heard, just 1 day in 2 years, and there's no time for her on the judicial calendar, then the state of the business requires that more hands be put on deck. And what is your view on the issue of Article 142.2, the use of the bar as the temporary reserve for the courts, that when the courts are overwhelmed, lawyers jet in, solve the problem, and then go back to their practice?
Thank you very much, Ellison. The issue of mission-based judges has, I think, hashtag or whatever that you're calling for. Mission-based judges or judges on a mission, in line with Article 142.2. I think is timely to the economic development and progress of our country. Is why don't we have specialized courts? You know, maybe some of these judges keep delaying matters because they don't understand them. With all due respect for our judges, that's why I use the word some or not all. So my take is, why don't we have, for example, specialized courts? We have the commercial court handling all commercial matters. It handles construction law matters. It handles intellectual property matters. And you can find that some of these judges that are sent to the commercial court are not experts on intellectual property. They are not experts on construction law. So we are saying that why don't we have specialized courts so that we have special lawyers who are specialized in a specific field, in line with the provision of the Constitution, coming with a mission and a mandate to do away, to handle those cases, because they are coming in as experts within their specialty. And they set up court structures for them. And they say now, like Ellison, we are appointing you a judge, and we are giving you a mandate to handle these matters for a period of 1 year. We are giving you about 40 construction law cases because you are a construction lawyer, and we are creating a construction law court under the commercial court, under the under the commercial court. We have the construction law court. So you come in as a legal expert, and they are giving you, you know, your mandate. If you have not delivered, because these things of appointing judges, without any, I don't know if they have to meet deliverables. I don't know if there are strict deliverables to say, for example, you are appointed and you're given these case files. If within your first 1-2 years of appointment, we see that you are not performing, the Judicial Service Commission will recall you. The Judicial Service Commission will recall you. So the whole issue is you have this judge, a specialist in construction law, under the construction law, handling only construction law cases. You have another mission-based judge like Anne Karunji, intellectual property law cases, under the intellectual property law case. So you find that how many cases are not die under the weight of I am green about intellectual property. So let me first keep adjourning that file. I am green on in construction law. So let me adjourn handling that involve international treaties international treaties and diplomatic immunities under the Vienna Convention. So you find that some of the, I saw a ruling by a judge that was oblivious of the Diplomatic Immunities and Privileges Act, oblivious of the Vienna Convention on diplomatic immunities. And then you find that guys are oblivious, guys. And so you find that a judge is admitting a country as a party to a suit, which cannot happen under the Vienna Convention without that party ratifying or accepting to waive its diplomatic immunity and be admitted as a party. So there are complex legal issues. So you find that judges, we need specialized courts for matters like that. So, yes, the issue of mission-based judges or judges with a mission under that provision of the Constitution is timely for our country. And I think that we need to do further engagement with parties that matter, you know, state organs, parliament, the judiciary itself, write a paper, so and cite some of these things so that it is actually put in practice. Yes, thank you.
Thank you so much.
I think you made a very clear case for mission-based judges, and maybe if we could switch this to Aaron and come to you. The rationale for mission-based judges seems very clear, very outright. What do you think is the thinking of the judiciary? How would the judiciary approach the conversation of mission-based judges, given your intricate knowledge of them?
Thank you. Here I want Papa to speak. I had to know not speak for the judiciary, how they think. I work closely with them. But this is my personal view. I think internally the Chief Justice is actually open to that. On various occasions, the Chief Justice has actually hinted on it, and it is a possibility that I think even the Minister of Justice is actually open to it, and it's a possibility that should actually be taken by together with the President, so that we actually actualize it. Because we have no any other way resolving the case backlog unless we first we have those mission-based judges or temporary judges, because we, as Uganda is a country now where we are, we cannot appoint the required judicial officers to actually clear the case backlog. Just 2 years ago, the budget of the judiciary was around 190 something. We thank God now that the judiciary's budget was actually increased by I think 150% to now 400 billion. They are working towards increasing it to the tune of 800 billion within the next 3 years. It has been stagnant at that for the past 3 years. We are supposed to have reached, I think, to the tune of that 800 billion, which I don't see that is going to happen even in the next 5 years. So we are still grappling with that. The second has been, which is actually a point that has been contention, is the discussion around the viability of these of what we are talking about, the logistical and budgetary constraints. Because we all know that temporary deployments we still require housing, security, and operational support, which may strain the national budget if not properly planned. Sustainability. People think exactly that temporary assignments are not suited for long-term solutions, such as building permanent courts and having full-time judicial officers, especially in under-served areas. The biggest concern has been people think that we will lack legal consistency and continuity because um, sometimes exactly some of these it's mission or then we will fail to actually have the continuity. Someone, but even when we're having these judicial what we have, for example, have decisions from the same court, from the same judge, confusing. And here you will not even go into details to mention some, but we all know some of those judgments that have caused us to know exactly those. But I also believe that even with that, with that, I think it is an open suggestion. Um, um, that the court, and we believe that even taking really Article 142 will provide constitutional tools for addressing judicial gaps in those areas if implemented with clear guidelines and logistical support. And we will definitely have to have some guidelines, some rules to follow, and as long as we do it in a very transparent manner, I don't see the reason why we should not have it. However, that can only be part of the broader strategy. Uh, Include more accessible courts and more accessible other jailous institutions across the country.
So much. Thank you so much, Councillor and Madam Anne. I think now, as we are moving into the short end of the conversation, I request those who have questions to either request for the microphone to speak, like how Madam Hope has done. Yeah, we shall add you as a speaker soon, or you can share them in chat or in box. We shall get you to answer your questions. At this point, I want to invite Mercy to ask any question to the other panelists which could be having.
For Mr. Aaron, I think your clientele are people who definitely need, I would say that people that you support, for instance, are people who need to have a good awareness and knowledge in terms of how they can access justice at an affordable price, at an affordable cost, but also to understand the kind of justice they can achieve by going to court or maybe going.
Is she still on?
Umuntu Wawansi in whatever district is aware of and be able to file, for instance, a claim with a small claims court when it comes to amounts of a certain value, or they can make a claim in the land. Do you think that enough effort has been put to ensure that there is awareness and the people know that they have these routes that access justice? Because no matter how much money is invested in if the people who need the justice are not informed or aware or even know where to start from other than going before a mediator, then it would be a futile exercise, in my opinion.
Thank you very much. Today is not the judiciary of the past 5 years. We have seen a tremendous shift, for example, in terms of community engagement and by the judicial officers. We are now increasingly having judicial officers engaging with the community through community barazas, through radio talk shows. I think there are more radio talk shows that the judiciary is conducting now than the last 5 years, which is now really a plus. But still, we still need a lot of engagement. It's not something that they are going to achieve within a short time. Going forward, we need reforms where judges and judicial officers, we stop looking at them as demigods or semi-gods. That one itself creates a very intimidating atmosphere, and that one distances them from the communities they serve. But increasingly, we have had actually really some of them have taken gradually really taking the steps of community engagement seriously, and I think if everybody really among the within the judicial ranks buys the approach, then they shall surely go there. But also the judiciary, they need the support of the lawyers, the Uganda Law Society, institutions like justice centers, so we actually drum some of these reforms, some of these awareness creation, and we empower the community so that the community is able actually to not only demand for the enforcement of their rights, accountability from these institutions, because these people are just not doing us, they are not doing us a favor. They are using our taxpayers, our money that we as taxpayers. So we should demand accountability on what they are actually doing, what they are not doing right, even what they are doing right. We should not look at them as like the way we really treat them. But also the whole culture. I am one of those people who believe that actually maybe the culture of our judges need to drastically change. I was in Canada and just few years ago, and we were just running around with the deputy chief justice on the streets, moving with no escort, with no cars, with no what, and the engagement between us and them was very conducive. But look at us, just even approaching a judge itself. You go to high court. When a judge is passing, they are busy pushing you off. Even lawyers, clear the way, clear the way, clear the way. Come on, that's thing that actually takes away from being even free. If now lawyers within the court system can be saying clear the way for the judges coming, what about the community? The community cannot feel free with the judicial service that is actually tamed in such a way. So for me, yes, we need to appreciate the efforts that has been done, but a lot needs to be done.
Just in addition to that question, thank you very much for your response. I want us to talk maybe briefly about the issue of ADR, keeping in mind that you're from Justice Centers Uganda. We do know that there's a point where mediation had become a mandatory step prior to proceeding in the litigation proceedings. And I know that people tried this alternative and most were futile unless parties are bound maybe by an arbitration clause in their contracts. That's when you see a lot of willingness because they're bound. But most of the mediation processes were just a ticking of a box. What value do you think ADR has added to the reduction of case backlog and also in increasing access to justice, not just to the people who maybe are challenged financially, but also to just commercial disputes and all these other disputes? And do you think that more steps need to be taken by the judiciary to make it the better way to go other than outright litigation?
I
think and we lawyers were party to blame. Mediation felt that maybe we are being cheated of our legal fees, the fees provided under that we are seriously inadequate compared to how you would actually earn if you went full-scale litigation. So my actual advice in regard to that is that I think we need again to revise the fees and under ADR so that the lawyers, who are a very big stakeholder, ADR succeeds, rewarded fairly well, so that they feel that is one of the easiest way of actually helping their clients, but also where they can and handsomely. Another aspect which for me, I use the Justice Center as a case study. I told you that 80% of the cases that come to us are resolved within our office through mediation by just inviting the other party and sit down, and we are able to resolve the conflict without necessarily. So that means that if Justice Centers, for example, was not there, those cases would have increased on the statistics that is actually in the system furthermore, and even other legal service providers. So for me, it portrays the importance of having a very effective ADR system that will work, and it will help us to unlock, to unblock some of those bottlenecks that we are facing currently at the system. So, one, the lawyers need to be adequately remunerated, but also the lawyers and the clients need to be adequately sensitized. Some clients feel that if they don't have their day in court, then they feel that they are being cheated. But for me, as someone who needs, so the fruit of my litigation or my dispute, what I want is to have how it is resolved is for me is none of my issues. As long as it is resolved and resolved effectively, then I would really go alongside. So we need to build the capacity and sensitize both the consumers and the suppliers of the justice services to have that ADR system effectively implemented.
Thank you. Thank you very much. Aaron, I just wanted to clarify to our listeners that ADR stands for Alternative Dispute Resolution. And that is for the resolution that is on matters outside of the courts. I want to move to Anne. Aaron has made interesting points. You've talked about the culture of judges need to change. And you've said, for example, when you're walking in the corridor of the High Court, some people may clear the way for the judicial officer that you shouldn't be walking on the same corridor. You should stand aside and bow to their lordship as they pass. You know, there's a matter where a judicial officer told a lawyer that I think what you have said is very stupid. And of course, the lawyer before court had to use court language, and so he replied, "Much obliged, my lord." That culture of being obliged as you are insulted is I think what you are saying needs to change. I know of another matter where a judicial officer told the state attorney at the end of a criminal session, "You are banned from appearing before me for the remainder of your natural life." And the state attorney responded, "My lord, I am much obliged. Even me, I don't want to appear before you for the remainder of my natural life." But my question to Anne is on the same trajectory, but maybe slightly differently. You had spoken about what you called judicial officers who are oblivious of the law, and you give a fantastic example of a case which you are handling where somebody has added a country to the case completely, and you use the word oblivious of diplomatic protocols, and some things you can even find them in movies, that you shouldn't be able to sue another country in the High Court of Uganda and add the embassy as a party to a dispute unless there are certain things which are clear. And so my question to you really along those lines is, what practical improvement could you propose to improve what could I call it, the quality of judicial reasoning and decision making? Because when judges make decisions, they're making law. People don't know that decisions of our judges bind future courts. Higher courts bind lower courts. So once the judge interprets the law, the judge is also doing what we call making judge-made law. And if judges are reasoning against the Vienna Convention, then against the Constitution, against the law, I mean, Anne, you've given us a number of practical examples where people are totally oblivious, and you have one solution which you've given us of specialized courts of if you're not up to it, you're not up to it. I mean, but what other proposals would you have to make to practically help ensure that the people who the noble and decent men and women who serve in the judiciary as judges and justices of the courts, as magistrates, that they're able to deliver quality decisions?
Thank you, Ellison, for that question. First of all, it goes right to the time when the judges put in applications to the Judicial Service Commission to be appointed judges. Who are those people who sit on the JSC? Who are they? What
and if I can interrupt you, very soon I shall be one of them, but maybe continue.
We will be happy to find you there. So now it is important that we look at right from the time of appointment. If we are going to have people who are going to have sound judicial reasoning, we need to look at the caliber of appointees. And also not even only the appointees, but the composition of the commission. Have we even ever bothered to find out, but apart from knowing the chairman of the Judicial Service Commission and maybe the 2 ULS appointees, do we know the other people? What is their public record? Who are they? What is their standing in society? What criteria they use in the appointing of persons to be appointed as judges? Yeah? Because that is key. Yeah? That is key for us to have quality people. It starts from right at that point when they present. For example, you are appointing a person who has never been in a courtroom, never argued a case, never written submissions. You know how we write submissions so that the judge can read them and deliver judgments. You are appointing a person, never been in a courtroom, never maybe works with somebody somewhere, a body, an authority, never really argued a case in court, never had a landmark decision. But why do we appoint judges to courts of record? Well, decision, because we must go back into the archives of the court and say, hey, this person argued this case, this person participated in this case. At least to Ellison, we keep seeing you in the newspaper in some famous case. We must see your legal reasoning in court, how you argue, but you get somebody from an authority, has no record, has no, you appoint them a judge. What do you expect really? Huh? Then secondly, if we can do away as a country with the vice of corruption, because corruption, we cannot turn a in this institution there is corruption. In this institution there is no corruption. We know that we are among those people. We have a ranking among the corrupt countries. So if, as long as in a country there is a vice of corruption, even in the appointments of people to serve in various institutions, others will be appointed through nepotism. Gamba no, who do you know what? So it also affects the output of well-reasoned decisions of persons who are appointed. Then in the resultant end is the decisions that come out. Then also I think there is need for judicial training. They can have visiting judges from other jurisdictions who can come and train these judges. Or they can go as studying judges and sit in other courts in other countries and see how do these people deliver timely judgments, how do they scrutinize and analyze evidence, how do they make sure, what do they look at. So it is important to benchmark. Then we have people like, we can also, get the services of we've a good caliber of judges like Justice Engona Ntende, who was, what was he in another country? DCJ, what? Chief Justice. Who have sat
Yes, he was Chief Justice of Seychelles.
Chief Justice of Seychelles, thank you. So we have guys like that, people like that, high caliber people who can train our judges yeah, so that they can have well-reasoned and sound decisions. Yeah, then they can have even experts. Why are they shying away from people like us? We are also experts in our field. The Judicial Training Institute can invite us. We invite us. There are so many lawyers. I have seen Nicholas online, Opio, Ellison, you there. There are many learned friends I'm seeing here who are experts in various fields who can be called on to train. Why are you shy to call a lawyer? You are not a jack of all trades. I might know what you don't know. Hmm? There's a time I asked the judge and said, "My lord, have you read this decision? Because it answers this case before you on all fours." The judge said, "I haven't read it." I said, "My lord, they are trying to bring a case that is stale." You know, there's that thing that a decision, after 12 years, a court order becomes stale, like stale food. Now, a lawyer will go and coin a court order into a fresh case. Yet the order was delivered in 2004, it expired. Then he brings it into a fresh case and then files it. Anyway, lawyers and lawyers' tricks. So I was just trying to ask the judge, have you read this decision so that you can understand your case? Maybe the judge is now retired. He was humble. He said, no, I haven't, but I'll read it. He was going to deliver a ruling. He stopped delivering it. He waited to deliver. He said, let me not deliver this ruling. Let me go and read the case, then we shall see. But unfortunately, he retired. So another judge did not whatever. He just came and delivered the wrong ruling that was on file. So there is need for adequate training. Yeah, so basically that is it. If we are going to have sound and quality decisions. Yeah.
Okay, thank you for that. I think you talk about corruption, and I think in 2021, I need to just get the study properly, but I know that in 2021, the Inspectorate of Government did a study on the cost of corruption in Uganda, and I think they said the judiciary has the highest cost of corruption, with the estimated costs paid by clients to bribe. It was something like $200 million or something like that. And I need to get the figures properly, but I think 43% of funding, 43% of funding in all, to the entire jail sector, I think that's the statistic, 43% of funding, almost half of the entire judiciary budget, I think that was the amount spent on corruption in the judiciary. So when you talk about corruption, there are some crazy numbers out there, but I think maybe Alfred has something. I think we also are opening up. We have a few minutes left, so we'll open up for a few questions from those who are listening.
Yes, thank you so much, Mr. Elson, and thank you for those who have raised their comments in the chat. I'll read out some comments as those ones who have questions can request for a microphone to speak, but I want to read these comments and then maybe one question which I received. Mr. Sentumbe says, Council and seems to suggest that mission-based judges can target lawyers that have proved competence in certain fields. This simply means that purely specialist lawyers, like in criminal law, would widely find themselves resolving land disputes and likewise. Then, regarding the Council is on judicial officers being demigods, he says this is really being more than radically perpendicular when it comes to how judges are treated by bodyguards, not as demigods. Then, so the question I received is for Council Aaron, because he made a very good case on mediation and noted that 80% of the cases are resolved through mediation, and if we can have few cases going to court, and so then we can also, that will enable us to handle case backlog. And he gave an example of justices whereby 80% of cases are resolved through mediation. And from my hand, I believe the only thing governing mediation of recent is mediation rules. I think I would propose probably having a mediation act to really regulate the mediation, and for the advocates to embrace mediation better, because I do think when they mediate a suit, they may lose out on some money. Would as well consider amending the mediation rules to to accommodate for fees of advocates where they resolve a matter through ADR or mediation, so that advocates know that they are covered even when they resolve a matter by mediation and not litigating entirely. But on the same comments, I would like you to propose what urgent measures can we embark on to really emphasize mediation now more, because you see its impact, because even before the matter, it first reduces on the case backlog by not even matters going to court, but even when the matters go to court, it helps to resolve some which have gone to court. So from your experience, what can be done to really have mediation embraced by everyone? That's the question I got from the comment section. Thank you.
Is he addressed to me or to I?
Yes, it's addressed to you, Mr. Aaron.
I hinted them of it in my presentation. One, as you also have adequately said, that you need to amend the rules so that the advocates are adequately remunerated. Those who participate in through that you are actually encouraging. Because today I believe instead of having 100 files within your office, which are all pending, some of them you take 10 years without ever resolving them. If you knew that you are going to adequately earn from them, then you would actually have them cleared within your system and take up new matters. But the second is actually for us as the community, for us to sense the community so that we stop this culture of litigation. I told you that many people just want to see their day in court, and simply because they believe that through litigation, that's when proper justice is attained. For me, that's not the way I see it. So I believe that we need to empower the community, to sensitize them, and also to sell the idea of ADR to it so that they embrace it wholly and then become. Another thing is for us to have so many centers for ADR established, like the way you are having courts. You look at the court annexed mediation. Court annexed mediation, for example, majority of them are just they are not there. The mediators are not there. Those even who can even help you to mediate the matters, they are not there. So we need to train first of all more mediators, but also equip them and have many other mediation centers across the country opened up, and then encourage people to actually utilize them. So must take a lead, because the roster now is now everywhere. Now even the towns that never used to have advocates, at least they are opening up. You find one or two at least advocates. Maybe apart some hard to reach areas, like for example, if you go to Yumbe, whether you go to the 7 districts of Karamoja, you really get a lawyer that is actually has opened up a law districts to go and handle matters there. But by and large, we are having now very many lawyers chambers across the centers. I mean, across the country. Some of those mediation centers in some matters where they would not be involved, maybe as parties or as counsel that are involved. So for me, it is the one sensitizing the public so that they embrace the mediation, to enumerate handsomely the lawyers involved, but also open up mediation centers where we can easily, where litigants can actually easily get the services when and then, so that we give the choice. People, those who want to go to court, because they would know that if you go to court, you go to court, and your matter is going to take 5 or how many years to be resolved. If I go for mediation, maybe within a year, I will have the fruits of justice that I have achieved. Thank you.
Thank you so much, Aaron, for that. And I realize we spent a lot of time, so we're going to get to our parting shots. But before we do that, maybe we would need to recognize the presence of the Vice President of the Uganda Law Society, Mr. Nsimwe Anthony. We're so glad that you have joined us today and that you're listening into these conversations. And if I could come to you and maybe ask you for your parting shots, where do we go from here? When do we vote to get the man in the seat that will get us the mission-based judges? And then we'll go to Aaron after that.
Thank you very much for that. As my parting shot, first of all, I'd like to thank Edison for organizing such important and timely conversations. This shows where the world is heading. That we do not even have to be in the same room, rent out a venue for us to have such important, discussions. But most importantly, is that moving forward, I think it is important that when we are having these conversations, let us invite members of the judiciary. For example, let us invite the judiciary spokesman. Let us invite maybe a chief registrar of the judiciary, so that they can hear and take this information back so that there is a holistic discussion, and we know that there's going to be solutions, because everything that has been said here is extremely important, and it is things that we have seen and things that we experience that affect Ugandans. So it is important that that important key stakeholders in government, because if we need mission-based judges, then we must be able to invite even the chairman of the Judicial Service Commission currently to sit in these, spaces. Well, at least let him decline the invitation, but let us invite him. Let us have, members of parliament, someone from the speaker's office, people who will push for change of policy to be able to sit in these spaces. Because everything that has been discussed here is key and very important, and we would not want it to end here, but we'd like to see that action has been taken. But also we can form groups and committees of people with Ellison leading that can find a way of engaging, or maybe even put out whatever has been discussed into, reduce it in writing or a paper of some sort, so that it can be used to engage with the policymakers, for the betterment of the people of Uganda and all of us in general. Thank you.
Much. Aaron, your parting shot.
Yeah, thank you very much. I also join Karunji to thank Edison for continuously engaging us in having this topical discussion, and I believe that we will make a judiciary that is responsive, or the justice sector that is responsive to the needs of the community they serve. In my passing, I want now to empower Edison that we need to reform the way the judges are actually appointed. And for me, I will vote for you on that basis. If you promise reform, we need a transparency. These judges are appointed. We need a system that is going to promote accountability. We need a system that is going to promote fairness. And we need systems that actually are going to be people-centered, not actually serving of the state and leaving the majority actually feeling that they are delivery of certain of certain services from government. Lastly is again I always say this, that we cannot talk about access to justice when the majority of the consumers are left aside. And these are the vulnerable, the marginalized, poor, that who are the majority, they form part. Actually, studies have shown that 8 of Ugandans cannot afford the services of private advocates. So tomorrow they may be them, tomorrow it could be you who need the services but you can't afford. So we must put also a system that will cater for both of us, regardless of their economic and political status within this country. With that, I want to thank you and want to thank the listeners for this engagement we are going on. And let us push and make sure that actually that we get the Judicial Service Commission. I feel that we have stepped back and we are not pushing enough. Thank God that Anthony, the Vice President, is actually is listening. We need now an action point. What are we going to do? We need our representation felt, and we cannot just sit idle and wait until the judiciary determines on what to do with us. Thank you.
Thank you so much, Mr. Aaron and Madam Anne, for your parting shots. It's been nice having you for almost 2.5 hours. At this point in time, I would like to invite Councillor to give his parting shots, but there's a question. Sorry, Councillor to give his parting shots, but while giving them, there's a question which I don't want to leave behind. One young lady requested you, this was Mr. Tim, requested you to comment on the delayed enrollment of young lawyers to the role, that they are also being denied justice because of being late to be enrolled as advocates. And maybe they could be also enabling access to justice if they were advocates, but 3 years later they can't even participate in such things because of the enrollment. So you could comment on that as you give us your parting shots. Thank you.
Well, thank you. Thank you, Alfred. On the issue of delayed enrollment, I think it's fair to call it a scandal. I mean, how it takes a Ugandan 1 day, it can take a Ugandan 1 day, or 1 week, 1 month to get an ID or a passport. It can take you 2 days or a day to get a driving license. A person who is qualified to appear on the role of advocates should not take 6 to 9 months, 1 year or 2 years to get onto the role of advocates. In a digital world, if someone qualifies, every step should be made to ensure that this person who has qualified is practicing his trade and profession. Delaying people is unconstitutional. I believe it's Article 42 of our Constitution that gives a fundamental human right to a citizen of this country to practice his trade and profession. If somebody has met all the legal requirements under the Advocates Act and under the various laws of this country for enrollment as an advocate of the courts of judicature, there should be no reason why he should wait 9 months, 12 months, 6 months, 18 months for his or her name to be entered on the roll of advocates. For every day that a qualified lawyer cannot enter the role of advocates, it is an economic punishment to that person. It is unconstitutional. It is unnecessary. It is unjustifiable. And I think those who are in charge will certainly help us to help move this process forward and to understand it better. Now, my parting shots. First of all, I am honored. I am privileged. I am proud and happy that my colleagues and friends, Aaron and Anne, have come on and have been firing on all cylinders. They have been saying the things that need to be said. And there are so many takeaways from this conversation. There are very practical things that have been proposed. We have had proposals about holistic discussions, inviting the judiciary into these spaces, preparing written papers, bringing the Speaker's office here, proposing reforms to the way judicial officers are appointed. In fact, that one has come even with a condition attached, a very important condition attached, that it is a vote, it comes with a vote, ensuring that we have a transparent method of judicial that we introduce judicial accountability in the way in which we are ensuring appointment of judicial officers. I welcome these ideas. I think we do need to have transparency. I do think we need to widen these conversations. And I do think we need to broaden this debate. There is also the fact that we must not sit by and ensure that the Uganda Law Society is able to elect its representatives, and that we must put our feet on the pedal more, and that we must bang the drums of reggae louder and make sure that that election happens. I think we've taken away fantastic good things. There's a point which had been made. Someone has now sent me the statistics that actually statistically, according to, I think, a 2021 report from the Inspectorate of Government, every litigant in the court system pays on average in corruption 300,000 shillings per case, per litigant. That somewhere along the way, somebody will part with 300,000 shillings. And I think it's a 2021 report of the Inspectorate of Government. And of course, if you're looking at, I think someone also sent me a quote that that does not take into account judicial avoidance. That does not take into account manipulation of the decision-making process in the courts. That does not take into account rubber stamping decisions of powers that be. That does not take into account absenteeism, laziness, lateness, rashness, sophistry, narrow-mindedness, misuse of judicial power, sweeping the concerns of the weak under the rug, judicial decisions, the purpose of which is to avoid embarrassing, powerful, corrupt institutions. That if you take all of that into account, then the 300,000 figure may be much higher. But that doesn't mean, of course, that we don't have great judicial officers, those rare custodians of conscience, those people who don't avoid the hard questions, those judges who face controversy squarely and resolve it justly, those judges who are the last fortress of the powerless, who are not absent but present, and who do not fear embarrassment for themselves or the truth if it is necessary for justice. And that therefore, you have judicial integrity, you also have judicial corruption. But whatever the case may be, I think what is important is that we have these conversations and make sure that we're able to move the conversation forward. From my side, it's been a great honor having you here, and we are certainly going to take all these ideas into account to ensure our conversations are holistic, are wider, are deeper. They go to the root of the problem. They touch the... I don't want to use a famous... metaphor, but there's a famous metaphor from a very powerful person about touching dangerous things. But we are going to try and ensure that dangerous things are touched to make sure that we progress this process and that we progress it with the necessary and deliberate haste. But for the lawyers, when we do get to fight, and we are going to fight, and soon, it won't take us a long time. I know I've been saying soon for some time, but we'll continue to say soon and it will happen. But we are going to very soon be updating colleagues on the steps we are taking to ensure Aaron's last point is met, that the Uganda Law Society sends its representatives. It is a scandal that up to this day, the Uganda Law Society has not been able to send representatives to the Judicial Service Commission. Just remember that the bar is those are the people who are allowed to stand before the courts of judicature. The 7,000 people who are allowed to represent 45 million Ugandans are not sitting in the room at the Judicial Service Commission. That is an unacceptable scandal. It is a judicial emergency that the judiciary certainly must take time off to look at and ensure that this matter is resolved with the necessary speed that is required. The fact that the lawyers do not have a voice in the room, that the clients do not have a voice in the room, that the Judicial Service Commission can be progressing without the voices of court users, that it can be happening in total avoidance and obliviousness to Article 146 of the Constitution, that it can be happening without the mind of the framers, that it can be happening on account of judicial decisions that are, anyway, I will not describe them, is, to me, totally and absolutely unacceptable, and we will certainly try and continue to take steps, because as far as we are concerned, at least us in this campaign, as far as we are concerned, nobody should and nobody can stop reggae. And when that time for voting comes, colleagues in the Uganda Law Society, just remember the question of Africo, the unavoidable question, the question that we have to ask ourselves with all seriousness. When that time comes and you're faced alone with your pen in a ballot, in a basin, the question lawyers will have to ask themselves is this: Oli mujawa musaja singanze.